Hello, my name is Michael McCarroll. I am an immigration lawyer. I practice in Denver, Colorado primarily, but my office assists clients throughout the United States with family immigration needs, specifically adjustment of status cases. That's kind of our specialty, and we have a great price for that. And in this video, I would like to discuss how to make your I-864 Affidavit of Support RFE-PROOF. How to make it so it doesn't cause you any issues going through the process. So probably the number one reason why someone might get their case denied is if they get a RFE for the Affidavit of Support and then they're unable to give a response that USCIS is looking for. That's very common, and I see that a lot. So what you would like to do is to avoid an RFE altogether. Unfortunately, USCIS does not play by the rules. Therefore, RFEs can be very common if you don't follow the guidelines that I'll put forward in this video. For example, let's say your income doesn't look great, but you have a lot of money in the bank. You have several $100,000s of liquid assets. The instructions say you're supposed to be able to use assets to qualify. That all makes sense. You provide all the documents listed in the instructions in order to qualify based on assets. And what happens? You guessed it. You're probably going to get an RFE because, again, USCIS does not play by the rules. Similarly, let's say your income for last year is low, but you're currently making a lot more money. Let's say you have at least 8 months at a new job with a much higher salary, and so your current income should be able to be used in order to qualify based on the instructions on the form and USCIS's own guidance. Let's say you submit the packet with proof of current income, and again, what's going to happen? Most likely you will receive an RFE. Okay, so these are a couple of examples of how USCIS really doesn't play by their own rules, and they issue boilerplate RFE responses to people who use assets, who use current income, and who don't follow the guidelines I'm going to set forth in this video. So that leaves you in a very awkward and uncomfortable position, right? Now you have an RFE where USCIS is saying, we don't accept the documents you've provided. There's not enough evidence of current income. And you have essentially two choices. You can suck it up and give them what they really want, or you can try to argue with them and say, oh no, this was good enough from the beginning and please take another look. If you don't get it right, the case will be denied, you'll lose the money and you'll have to start all over. So most of the time people are going to want to just suck it up and do what is advised in this video, the path of least resistance, and just provide USCIS what they're really looking for. And what is that? It's going to be a W-2 or a 1099 form or multiple W-2s and 1099 forms for last year. That is what USCIS wants to see in order to qualify an 864. This is the advice that I give to all of my clients, but of course my clients are in charge, and if they decide that they would like to move forward with a submission of assets and stuff like that, we do it. But every single time it does result in a request for evidence. And so the people who are trained at USCIS are not following their own rules, and it is just not even worth it. If you do not have the income for last year based on a W-2 or a 1099 to qualify as the U.S. citizen petitioner or the permanent resident petitioner sometimes, then you need to get a joint sponsor who qualifies based on, you guessed it, either W-2s or 1099s from last year. And of course, the petitioner or the joint sponsor, whoever it may be, who's seeking to qualify themselves based on these tax forms for the last tax year, needs to still be employed. So you cannot rely on a W-2 for 2021, for example, which would be last year currently, and expect that to work in all cases. If the petitioner is not currently employed, that's the one situation where USCIS would not accept that. However, if the petitioner or the joint sponsor is currently employed and perhaps they're making a little bit less this year, you can still use the number from the W-2s and the 1099s from last year. The year's not over yet. You don't know exactly how much they'll make by the end of the year, so that's the number figure we use. Another situation where a W-2 and 1099s will not work is if the total income as listed on the tax return is less than what's shown in the W-2s and 1099s. For example, let's say you made $100,000 at your salaried position, but you also had a business, and that business claimed a write-off or a loss of $90,000. So your total income on your tax return is only $10,000. In that case, even though you have the W-2 to show the $100,000, because the total income on your tax return is much lower, USCIS will go based on the lower number. And so in that situation, it wouldn't work. Let's take another example. Let's say you drive semi-trailers for a living and you have $350,000 worth of 1099 income. But at the same time, you pay a lot of money for gas and expenses. So let's say you write off $330,000 worth of that income, and your actual total income line on your tax return is $20,000. In that case, they're going to go with the lower number, and you won't be able to rely on those 1099s for your business. Again, if you do not have W-2s or 1099s to prove the income, then our recommendation is to get a joint sponsor. While you may be able to get away with it without a joint sponsor, you certainly are probably going to receive an RFE. It's going to be very stressful, and you're not sure if it's going to work. If you are working with the National Visa Center, however, so your case is being processed outside of the United States, the National Visa Center is more likely to actually follow the rules and to accept, for example, assets or current income to meet the Affidavit of Support requirements. We still recommend that if you do not meet the threshold income level based on last year's W-2s and 1099s, that you use a joint sponsor. However, if you absolutely cannot find a joint sponsor and your case is going through the National Visa Center, then you probably are going to be able to use assets or current income to have your I-864 document qualified by the National Visa Center and ultimately approved by the consulate. So let's take a look at this in practice. Now I will give you a step-by-step guide on how to complete the I-864 Affidavit of Support in such a way that you are not likely to receive a request for evidence from USCIS. Let's take a look. The first thing you need to do is make sure you're downloading the I-864 from the USCIS website and you are using the correct version. So let's do that now. And you can see the edition date is the 12/8/2021 edition currently. This edition date here on the USCIS website is what you want to look at. And you'll download the form there. Here's the form. You'll notice up here that there's an expires date on top of the form in the top right corner. You can't ignore that because the edition date at the bottom left is what you will be using. And sometimes they will use the edition of the form that goes beyond the expires date in the top right corner, and that can sometimes confuse people. But don't worry about what it says in the top right corner. I'm going to download this form and we are going to fill it out together here. Here on the left is where you will put the name of the U.S. citizen petitioner or the permanent resident petitioner who filed the I-130 for this case, or is filing the I-130 concurrently with this case. You'll check the box, I am the petitioner here, the top left. Of course, this is being completed by the joint sponsor, then they will select I am the only joint sponsor here. Keep in mind that even if you use a joint sponsor, the petitioner still must complete an I-864, even if they don't work. So we'll check I am the petitioner there. Then the form goes straight into asking questions about the immigrant. This is all self-explanatory. You put the name there, the mailing address in the top right there, information about birth, alien registration number, if any, there. The immigrant will likely not have an alien registration number in a lot of cases, especially if this is a one-step adjustment of status case where you're filing the I-130 and the 485 together. However, sometimes the immigrant will have an A number and you would want to include it there. The USCIS account number there for the immigrant, if they have one. A lot of times you will not have one. The daytime phone number for the immigrant. And then part 3. Here you'll check yes, I am sponsoring the principal immigrant named in part 2 at the top. Now, it's very rare that you will be including additional family members on this form because an immediate relative of a U.S. citizen does not have derivatives. You cannot attach their children, for example, to the case, and so they would not be included here. The number of immigrants you are sponsoring on the form, that is most always going to be 1, unless there are derivatives. Then the questionnaire or the form goes back to asking questions about the petitioner, so usually the U.S. citizen or perhaps a permanent resident here. The sponsor's full name here must match the name on page 1. And sometimes if people handwrite this in, and the names don't match exactly, then you could get an RFE for that. So be careful about that. We always recommend that you type in the form anyway. The sponsor's mailing address will go there. The physical address, if different. Country of domicile. So the sponsor needs to be domiciled in the United States. The sponsor cannot sponsor their family member if they are outside of the United States. The only exception is if the sponsor will be moving to the United States at the same time as the immigrant, and this is a consular processing case going through the National Visa Center. But for cases processed in the US, where the adjustment of status case is taking place before USCIS, the petitioner is always in the US anyway, and that is a requirement that they be in the US, be domiciled in the US. Of course, there's exceptions for military family. So country of domicile, date of birth, city, state, and country of birth, social security number is absolutely required here. The sponsor petitioner will either be a US citizen or a lawful permanent resident. Even if the petitioner is currently a US citizen, if they naturalized and had an alien number before, that alien number or A number should be included here. And you'll want to indicate if the petitioner sponsor is on active duty in the U.S. Armed Forces, because if so, the income that is required to meet the qualification is less. Then they want you to add up the family size. There will always be a number 1 here. And when you place the number 1 above, then it will also go there. You do not count anybody twice. So if the immigrant is the spouse of the petitioning sponsor, then you would not put a 1 for are you currently married. You would not want to include the immigrant twice there. Dependent children must be included. Other dependents must be included. If the tax return shows that you're writing off, 5 of your nephews, for example, then they're not going to let you claim that your family size is 2. Essentially, even if you don't plan on writing off those nephews in the future, because they're on your tax return, your latest filed tax return, then they're going to say that you need to add them to your family size here, and you may need a joint sponsor in that case. So you'll include all the people here, anybody you've previously sponsored who's currently a lawful permanent resident still and has not become a U.S. citizen would also need to be added to the family size. And then the total household size will be here at the end of that. To determine if you make enough money, you'll want to Google I-864P and go to this page. On this page, you'll click where you live, so either Alaska, Hawaii, or the other 48 states. If you're in the military, you'll use 100% of the poverty guidelines. If you're not in the military, you'll use 125% of the guidelines. And so if it's just the sponsor, for example, a U.S. citizen petitioner filing for their spouse with no children, no dependents, it's going to be a household size of 2, and you will need to show at least $22,887 currently based on W-2s and or 1099s for the last tax return filed. And then as you add additional family members, then the amount increases here. Here, the sponsor's employment and income. So the sponsor must be employed or at least self-employed, or perhaps if you are using 1099s based on retirement income, perhaps you could say retired. But if you say unemployed here and you do not have essentially pension-based 1099s, then that's not going to work. You are obviously going to need a joint sponsor in that case. And then this is the number one most important number here. My current individual annual income is what? Okay, that's what we talked about needs to be proven based on the W-2s and 1099s. So let's say you have $50,000 in a W-2 from last year on your 2021 tax return. But let's say you're making $75,000 currently. And also last year you made $20,000 in business income, but there's no 1099s connected to that. What number are you going to put here? Is it going to be your current income plus your business income? Is it going to be last year's W-2 number plus last year's business income amount? It is going to be, should be the W-2 amount for last year. So the $50,000. I understand you made more money last year. I understand you're currently making a lot more money. But the fact of the matter is, USCIS will look at this number and compare it to the W-2 and or the 1099s that you have from last year. And in this case, $50,000 is way above the threshold amount, so you're fine anyway, okay? So that's what the number we would use here at my office for the individual annual income amount. Income you are using from any other person who was counted in your household size. Generally, we sometimes can use income of the immigrant living and working in the United States if the immigrant also has a W-2 or 1099 from last year, they filed their taxes for last year, and they're currently authorized to work, such as with an H-1B or something like that, and we can include that with the case. So we might add their income here if necessary. This is a threshold question, so we do not need to go much beyond the threshold number. So if the U.S. citizen's spouse makes enough money and they otherwise qualify, we don't need to add income from the immigrant here if it's unnecessary. And again, it would only be possible if the immigrant was currently in valid status, such as an H-1B, an L-1, some kind of visa like that. They filed taxes for last year, they have a W-2 or a 1099. This number here, number 20 on page 5, that number will equal the individual income amount from the previous page here, except for in the rare cases where you may include income from the immigrant. There are additional forms such as an I-864 if you want to try to include household member income and stuff like that, but that gets a lot more complicated. So generally speaking, the number here for current annual household income will match exactly what is listed as the individual income for the U.S. citizen petitioner or the permanent resident petitioner. If, however, you are adding the immigrant's income to the form, you would check the box. One or more of the people listed in items number 8, 11, 14, and 17 do not need to complete form I-864 because he or she is the intending immigrant and has no accompanying dependents. Okay, question again for the U.S. citizen petitioner or sponsor. Have you filed a federal income tax return for each of the 3 most recent years? This really should be yes, unless the petitioner was not required to file a tax return for any of those years, in which case you could potentially say no, and in that case you would have to check the box, I was not required to file a federal income tax return and my income was below the IRS required level, and I've attached evidence to support this. So essentially, when a petitioner, let's say the U.S. citizen or LPR petitioner spouse, for example, was at the university studying and did not make any money for the year of 2019 and 2020, we would put 2019, 2020, N/A, but we would need to provide an affidavit from the petitioner saying, I did not earn any money at all for these years. I was living off of student loans or support from my parents or whatever, and therefore I did not file a tax return, and we would have to include regulations and other documents from the IRS to prove that the petitioner was not required to file taxes for these years, okay? And sometimes if there's a missing tax return, it's easier to just file it, quite frankly. They're going to require that the petitioner provide numbers here for the last 3 years and indicate that they have filed tax returns for the last 3 years, or they're going to require proof that the petitioner was not required to file. And if the petitioner did not file for the last tax year, currently that would be tax year 2021, then you're going to need a joint sponsor, obviously. Okay, there is an option here. I have attached photocopies or transcripts of my federal tax returns for my second and third most recent years. Not required, okay? We only use 1 year of tax returns at my office every single time. Again, you do not have to overachieve. This is a threshold requirement. So we use the last year's tax return. It says right here, the other 2 tax returns are optional, so we do not include them, and that's it. So I do not recommend including more documents here than you need to. Now it does say here that you could potentially provide transcripts instead of tax returns, but we have received RFEs when providing transcripts, even though the form itself calls for them. And again, that's because USCIS does not follow their own rules. And so I recommend providing tax returns. So you can just essentially print it off TurboTax or Tax Act, or get a copy of what was submitted by your accountant and provide that together with any W-2s and 1099s, if any. Assets, again, this section, if you were filing an adjustment of status case with USCIS and you need to use assets, you will get an RFE. So it's much better to just start out with a joint sponsor if you can. And a joint sponsor would essentially need to have the same income requirements that the main sponsor would need. Okay, so that's essentially the form there. So the form will be submitted with proof that the U.S. citizen or permanent resident is a U.S. citizen or permanent resident. When we submit an adjustment of status packet, that information, especially if it's a one-step adjustment, those documents are submitted with the I-130. But you need to make an extra copy and put it together with I-864, or you could potentially get an RFE for that. So you always need to provide proof that the petitioner is a U.S. citizen or a permanent resident. USCIS does not require evidence of domicile, fortunately. The National Visa Center definitely does. So if your case is processing through the National Visa Center and you will go to an interview at a consulate abroad, you need to upload proof of domicile to the National Visa Center, such as utility bills, mortgage statements, etc. But for the adjustment of status cases going through USCIS, if you indicate you're domiciled in the US, you filed a US tax return, you have a W-2 or 1099 showing US income, fortunately, USCIS, I've never seen them require proof of domicile, such as a utility bill or something like that. So you'll include the proof that the petitioner is a U.S. citizen or permanent resident. You'll include the last year's tax return, currently 2021. We do not recommend using transcripts. And then you'll include the most important documents, which are the W-2s or W-2 and 1099s, if any. And if the petitioner is still employed, if the numbers shown on the W-2s and 1099s add up to more than the threshold, and if the tax return for last year does not have a total income amount less than the W-2s and 1099s, then you basically have almost an RFE-PROOF I-864. And that's what we like to submit at my office, because getting an RFE is not a lot of fun. And if you do not respond in a very precise way, USCIS often does just deny your case, and then you're out, $1,225, because what happens when they deny your case, they don't deny the I-130. So at least you got that through in pending, but then you have to usually refile your I-485 Affidavit of Support. And so you're at least going to lose $1,225 if you don't do this right. So that's what we recommend doing, the path of least resistance. If you feel like you really want to use assets, or you really want to use current income and the instructions say clear as day that you should be able to do that, just think twice. Try really, really hard to get a joint sponsor first. It can be any friend or family member who lives anywhere in the United States who is a permanent resident or a U.S. citizen who's willing to sign this form and provide their tax return, their W-2s, other basic information, and is willing to help you. If you look hard enough, you can usually find somebody that's willing to help you, and that's vastly better than trying to use assets or current income. All right, Well, that's all I have to say on the issue. I hope you enjoyed the video. I hope it's very helpful. As always, this is not legal advice. This is just educational material. You should definitely work with an attorney if you can afford it. Thank you and have a nice day.